Good morning, everyone. I wish to welcome the viewing and listening audience to the 21st meeting of the Joint Select Committee on Finance and Legal Affairs. Today, the committee is convening its first public hearing pursuant to its inquiry into the performance of the Financial Intelligence Unit of Trinidad and Tobago in relation to anti-money laundering and compliance with terrorism. Now, members of the listening and viewing audience are invited to post or send your comments via the Parliament's various social media platforms, Facebook page, Parliament YouTube channel, ParlView, and that's generally how we expect you to communicate with us. We try our best to respond to you. I'd like to welcome officials of the Financial Intelligence Unit of Trinidad and Tobago, the Central Bank of Trinidad and Tobago, Anti-Terrorism Unit, Office of the Attorney General, Ministry of Legal Affairs, and Trinidad and Tobago Securities and Exchange Commission. So we have quite a powerful group of people in front of us this morning. I am Hazel Thompson-Ahi. I'm the chairman of this committee, and I now invite the other members of the committee to introduce themselves to you.
Good morning, everyone. Simon de Nobrega, member.
Morning, everyone. Lawrence Islap, member.
Good morning, everyone. Hassel Bacchus, member.
Good morning, everyone. Jayanti Lachmadial, member.
Do we have everybody? Now, the members of the officials here, I'd like you to introduce yourselves. Could we start with FIU, please? Financial Intelligence Unit of Trinidad and Tobago.
Good morning, Chair. Good morning, members. I am Nigel Studdard, the Director of the Financial Intelligence Unit. I would like to introduce my team with me here. It's Ms. Mary Campbell, the Deputy Director of the Financial Intelligence Unit, Mr. Kevin Radix, the Director of Compliance and Outreach, Ms. Candice Thomas, the Supervisor of Compliance and Outreach, and Ms. Shivana Sharma, our Legal Officer 2 at the FIU DT.
Official of Central Bank, please.
Good morning. I am Patrick Solomon, the Inspector of Financial Institutions. Accompanying me today is Mrs. Michelle Francis Panto, Deputy Inspector of Financial Institutions, and Mrs. Nadira Rahamatullah, Manager of the AML Unit.
Officials of Trinidad and Tobago Securities and Exchange Commission.
Good morning, Chair and members. I am Kester Guy, CEO of the Trinidad and Tobago Securities and Exchange Commission. With me is Mrs. Rosalind King, Director of Compliance and Inspections. Thank you.
Thank you. So welcome. Attorney General and Ministry of Legal Affairs, Anti-Terrorism Unit.
Hi, good morning, everyone. My name is Cassandra Sitahal. I'm a Senior Legal Counsel in the Anti-Terrorism Unit, Office of the Attorney General and Ministry of Legal Affairs. With me is Ms. Milan Chucheng Donowa and Mr. Kapan Prasad, both legal officers in the Anti-Terrorism Unit, please.
The objectives of this inquiry are to determine the money laundering, terrorist financing risks and trends in Trinidad and Tobago, to determine the effectiveness of policy and legislation to treat with those issues, and to assess the performance of the FIUTT with respect to its effectiveness in managing the country's anti-money laundering counter-terrorist financing regime. I will now ask certain members here, the leaders of the organization, to make brief opening remarks, maximum of 2 minutes. I know you can say a lot on these very pressing issues, but we just ask you for 2 minutes. You will get your opportunity to expand as we go along questioning you. So, Mr. Nigel Stoddard, we start with you, please. Director of FIU TT.
Thank you, Chair. I will be as brief as I can be. Firstly, I would like to thank the committee for this invitation to participate in the 21st public hearing of the inquiry into the performance of the FIU-TT. The FIU-TT welcomes this opportunity to share with the committee, stakeholders, and the general public the pivotal role in and its continuous efforts towards combating money laundering, terrorist financing, and proliferation financing with its stakeholders. A country's global financial reputation is a direct reflection of the efforts made to safeguard the integrity and stability of its financial institution. FATF Recommendation 29 requires countries to establish an FIU that serves as a national center for the receipt and analysis of suspicious transaction reports and other information relative to money laundering, financing of terrorism, and proliferation financing. The core of the FIU is an intelligence gathering agency responsible for collection of financial intelligence and information, the analysis and dissemination of said information to law enforcement and other competent authorities in Trinidad and Tobago, as well as outside of Trinidad and Tobago. The FIU-TT acknowledges that the anti-money laundering, counter-financing of terrorism, and counter-proliferation financing landscape is one in which is a changing dynamic with evolving technologies, increasing innovation, modalities of crime, and nature of vulnerable business sectors. The FIU-TT appreciates the importance of the continuous improvement in the performance of its function. Increased focus is placed on stakeholders' collaboration, supervisory and regulatory coordination with varying counterparts, and the conduct of sector-specific anti-money laundering, counter-financing, and counter-proliferation financing outreach sessions. The FIU also participates in the review of relevant AML and CFT legislation through its membership in the NAMLAC. That's the National Anti-Money Laundering Committee of Trinidad and Tobago, whereby the vital contributions are made for the enhancement and amendment of legislation necessary to ensure the anti-money laundering, counter-financing, and counter-proliferation financing legislation and regulatory regime in Trinidad and Tobago remains relevant. In this vein, the FIU-TT looks forward to participating in this JSC and undertakes to provide any clarity sought and give a true representation of its operations. Thank you, Chair.
Well done, well rehearsed, timed. Mr. Patrick Solomon.
Good morning, Madam Chair and members of the committee. The FIU, the Central Bank, and the Trinidad and Tobago Securities and Exchange Commission are all members of NAMLAC. In this regard, the three agencies collaborate frequently to ensure the resilience of the financial sector to constantly evolving illicit financial threats. Such collaboration includes the sharing of information and working together on the development of policies, guidelines, legislation as necessary that reflects international standards for AML and CFT to ensure that the domestic regime remains appropriate for addressing current and emerging money laundering risk issues. At the end of the day, we are stronger together. The Central Bank therefore looks forward to contributing to this discussion, and we stand ready to provide further information as needed.
TTSEC.
Chair and members, good morning again. The TTSEC is very pleased to be part of this dialogue today. We hope in sharing our contributions, we will be able to demonstrate the work that the FIU TT at the central bank have been undertaking to ensure that our AML regime remains appropriate, up to date, and we are conducting our business in line with the general standards provided by the global standard setting bodies. The TTSEC is responsible for protecting investors within the securities space. We also contribute significantly to ensuring that market integrity is maintained, and we partner with other stakeholders to ensure that overall financial stability is also achieved. This collaboration that we will discuss today will also provide some greater insights to you and the wider public on how we achieve these objectives, and we look forward for your questions and queries. I thank you.
Thank you. Now we have Ms. Cassandra Sitahal, Anti-Terrorism Unit.
Good morning again, everyone. The Anti-Terrorism Unit continues to work diligently towards fulfilling the obligations and the functions of the Honorable Attorney General pursuant to the Anti-Terrorism Act, Chapter 1207. In doing so, we look closely to the implementation of the domestic framework, but as well as the international framework, which includes United Nations and the mandates of the United Nations Security Council resolutions, as well as the FATF standards that fall under those international standards. The Anti-Terrorism Unit is also a member of the National Anti-Money Laundering Committee and work closely with all the key AML, CFT, and CPF entities in Trinidad and Tobago. And as the others would have said, we look forward to the discussions today and remain available to answer any questions that may come our way. Thank you.
So, we start off with the Financial Intelligence Unit of Trinidad and Tobago, FIU-TT. We've looked carefully at all of your submissions, starting with your agency. Page 1 of the submission itemized the reason for the submission of suspicious transactions and suspicious activities report, in which the following was noted: structuring transactions, that is where there appear to be attempts to break transactions into smaller amounts to avoid reporting thresholds. How are such expertly strategized structured transactions identified when they are conducted electronically? Tell us, please.
Thank you, Chair. Those transactions identified by the reporting entity, in most instances the financial institution, which may be the banks, they are required to have transaction monitoring systems in place to monitor transactions that are deposited as well as withdrawn from their customers' accounts, and based on their set requirements for the transaction monitoring, they can identify if transactions are being deposited frequently below a certain amount, or if transactions are being deposited within a certain time frame as well. Those transactions supposed to raise alerts, which the financial institution would then conduct their own internal inquiry before making a determination to file an STR or not.
And then they report those to you?
Yes, Chair.
I see. Thank you. Mr. Hislop?
Thank you, Chair. We're dealing with the illegal sale of foreign currency. And you shared with us that persons selling or purchasing foreign currency without authorization from the Central Bank of Trinidad and Tobago commits a breach of the Exchange and Control Act. And so before I get to the question, or I'll add this into the questions as well, if I am a regular citizen and a family member comes from the US or from Canada, they have foreign currency, Are you saying to the public this morning that they are breaching the Exchange and Control Act by purchasing that foreign currency off of that?
If you buy it,
If I buy it from that family member.
To answer Member Hislop, the legislation is clear in the sense of persons who do not have a license from the central bank, an authorized license, in terms of purchasing or purchasing and selling, of foreign exchange, as the case may be. Knowing our culture, that aspect of it, if someone is returning, as the example you gave in terms of a family member, generally that person is not, in my view, is not in the business of selling or purchasing foreign exchange. However, as we indicated, once someone in that capacity goes to the financial institution, as the example you would have given, and of course the banks they have their customer due diligence requirements that they would perform, and including that would be the source of funds. And being an honest transaction, an honest person would indicate where they would have gotten the funds from. Again, it comes back to the legislation, and the view may be that they determine that is considered suspicious and file a report with the FIU TT.
But how much of a concern is the illegal sale of foreign currency considered by the FIU? And I ask that from the standpoint that you have so many retail outlets throughout of various sizes throughout Trinidad and Tobago that have these signs posted, we purchase USD at 7 to 1 and so on. Or 750 to 1. How much of a concern is that to the FIU?
Again, most of those, what you would have described, remember, is outside of the FIU remit in terms of what the FIU would actually be privy to in most instances would be what the financial institutions or the listed business report us via STRs. Like you, I do traverse and see the signs in the stores as well, but that would fall within another entity remit in terms of the legality of it or how that is treated in terms of that type of activity. Like I said, there's a culture in Trinidad and Tobago that prevails, but that aspect would be with another authority in terms of who determines in the use of or the trade in foreign currency, which is generally done by the central bank.
Can the central bank, do you wish to add something on this particular issue as a regulator?
Yes, Madam Chair, I can add. This, according to the Exchange Control Act, you must be an authorized dealer in order to buy and sell foreign exchange. However, as part of our surveillance of the market, we have seen the ads and we have sought legal opinion in terms of whether it is legal or not. And based on the opinions that we got, it is saying that if somebody purchases or sells foreign exchange, they are committing an anticipatory offense of conspiracy, aiding, abetting, attempting, or counseling or procuring the sale of foreign exchange contrary to our section 6.1. And therefore, if an authorized, unauthorized person advertise the purchase and sale, it is arguably an offense. However, we looked at the act and we asked legal counsel, senior counsel, their opinion, and they have the opinion that the legislation should have a specific offense. And in order to have this specific offense of advertising, we needed to amend the legislation. But in the interim, what we do, if there is something like a whistleblowing, we contact the TTPS, who will do an investigation. And once the investigation is completed, they refer it to the Director of Public Prosecution to determine whether or not there is a case to be had. So that's the process that we tend to follow in this situation.
So the scenario that Mr. Hislop outlined with family members and friends, that wouldn't be caught by this provision, would it?
Yes, it would be caught because, remember, you went to the bank and you stated the source of funds and the bank reported a SAR, a suspicious activity. What the banks tend to do, they have a profile of every customer and they know what is normal. And if you do not normally go and change foreign exchange, that is abnormal, and this is the basis for filing the suspicious activity report.
Right.
I'll allow, and then I can come back to I'll allow.
Thank you.
Them.
Good morning,
Good
Inspector.
morning.
And this is where I think the risk-based approach is important, because I don't know, we're looking at this in the context of money laundering.
Right.
For example, if a person, my auntie comes from Florida and sell me $500 US because she wants TT dollars to spend to take a maxi or whatever, she wants some change, there's no money laundering risk per se, so it's an extremely low risk involved in a transaction like that, as opposed to someone who, and then I think somewhere in the middle of the line, you're looking at stores which are accepting US dollars in exchange for goods and services because they themselves need foreign currency in order to purchase the same goods that they want to bring in. And then you have the other scenario where you have people on the next end of the spectrum with people actually trading, buying and selling currency. So, I don't know if you're reading directly from your legal opinion, but I understand what they are saying in terms of advertising that I'm willing to accept US in exchange for goods that I would have purchased myself with US as a store or something like that is different in terms of money laundering risk, as opposed to I am buying from people who perhaps work outside of the jurisdiction, or because there are people in Trinidad and Tobago in the oil and gas industry who get paid in US dollars. They withdraw their money from their US bank account when they can, and they are selling it at $8 and $8.50 and so on. And I am buying from them because I buy in bulk, and I'm withdrawing a substantial amount of Trinidad and Tobago cash, buying it for $7.50 and reselling it for $9 or $8.50. That means I'm an actual trader and ought to be registered with the central bank. So in terms of assessing the risk of those three different categories of people and deciding where you should focus your energies and go after and determine how you should craft your legislation to create specific offenses to deal with those three different types of scenarios, have you all looked at that and looked at the type of amendments needed to the Exchange Control Act?
Yes, because as you say, risk-based depends on what are the significant activities, and then you categorize them into high, medium, and low. So the example that you're giving will be a low-risk activity, but it's still an offense, and we haven't devoted a lot of time in that particular activity. So we know it exists, and we know we are doing risk-based, and therefore we would look at possible amending of the legislation, but it's risk-based, so we don't look at every particular transaction. Right. We look at the significant ones.
But risk-based also means that through you, Chair, risk-based also means that you as a regulator and the creator of offenses or the recommender of offenses under the law, you also have to take into account whether you want to create an offense that could be used to criminalize somebody buying some foreign currency from their family coming from abroad. So you might have to look at thresholds, for example.
Right.
Right?
So
you may consider, for example, a threshold as to, and even in that middle scenario that I described, create a threshold that you cannot accept over a certain amount of US dollars if you're selling goods and services as a a clothing store, because we have to take into account the scenario of existing businesses right now, particularly small businesses who purchase goods with US dollars but cannot get to buy from the bank in a certain amount, so they may wish to sell and accept US in exchange. When we're trying to boost tourism, you have tourists coming into the country, they may want to spend US dollars right down by the port and sell to our crafts men and women.
Is there a
So
question?
do we want to, sorry,
Question
well, I'm
for
asking,
him?
have you really considered thresholds and taking into account those scenarios, and how and when can we see some more, because the longer we analyze,
Member, Latrinia,
yes,
question.
Chairman, are we not exposing ourselves to the risk of people conducting the higher risk activities, and we are not able to regulate any of them because we're looking at too broad of a scope of these different types of activities related to foreign currency?
Exactly, that is what we're doing. We are looking to amend the Exchange Control Act and to have a number of situations and determine thresholds. Like, for example, you're thinking about having a cash threshold. In some jurisdictions, they have a cash threshold. So, for example, if you deal with cash over a certain amount, it must be reported in other cases. So, as part of our analysis and the implementation of the Act, we look at the various scenarios and come up with what we consider to be high, medium, or low, and what are the consequences of it. So yes, we are going to look at it to see how best we could administer the Act in terms of its implementation.
Let me say, you spoke about an intended amendment to the legislation. Now, there are many pieces of legislation, you know, in the pipeline. How close are you to having this, you know, come before us? What is the status? Can you say?
It's currently being reviewed, as I was saying, that we are seeking legal advice, and based on the legal advice, they are telling us that they are going to, if we do one particular thing, it would lead to a possible constitutional issue, and therefore you would have to look at the various scenarios. So normally with legislation, it takes sometimes like 2 or 3 years in order for it to be implemented, but we are doing our homework, our research. We are seeing that what needs to go to Parliament to get a special majority, whether it is going to affect people's constitutional rights or not. So this is the status. So you can't really determine when the legislation would come into place. You will have a process that we follow. So we do our research, we determine what are the principal provisions that we want to change, and then we go to the legal department to draft the legislation. So it's a long process. So I'm saying it's very difficult sometimes to determine when it is going to happen. But in the meantime, we are aware of the issues, and in some cases, we exercise forbearance.
Is you look at the political climate.
Yes, as
I
well.
see. I
Yes,
see.
you said.
Yeah. Yeah, please, and good morning again. There was one aspect of this, and Chair, through you, just for the public, because it's one of the things I was bombarded with. Here you're going and talk to FIU, find out about this for me. And it has to do with cash. So my line of questioning will come around cash. A number of people would have asked that they, over an extended period of time, would have been traveling to foreign countries. And in doing that, would have, on their return, continued to keep whatever additional funds that they had when they returned to Trinidad and Tobago. So I've been traveling for the last 7 years. I'd travel to the US, I'd come back with currency, and I would keep it. And so there really is no significant trail of source of funds for this. This is just accumulation of money over time. The question is, one, by having sums of foreign currency in your personal possession, does that itself constitute something that could be considered? And two, if I try to deposit those things eventually and say, listen, I'm fed up having this in my mattress home in case of fire, I want to put it in the bank, what happens? Are these things also the kinds of triggers that could land people in trouble?
I should like to point out that members' statement was hypothetical.
Yes, it
I
is.
would not like anybody to come to look for his mattress.
No,
Right? That's all hypothetical. You're just putting
thanks for the
something.
clarification, Chair.
Yes,
Thank
I
you.
wouldn't want anything to befall you, sir.
Yes, I have a divan.
Thank you for your question, Member Bacchus. There's two scenarios to that. One being that normally, if the sum is above the declaration that a traveler coming back to Trinidad is supposed to make, they can make that declaration once it's above the prescribed sum. As you indicated, if it is that it's below the prescribed sum and persons traveling regularly and have those sums, it goes into the next scenario where they go to the financial institution to deposit. Again, as I said before, the financial institution have their obligation under the financial obligation regulation to ask in terms of the source of funds and some level of evidence that this amount of money that is now being presented to them is from a legitimate source. And they would require certain evidence. I'm not certain what they may ask. They may ask to see your travel history. They may ask other information in terms of your occupation and so on. And again, based on that and based on the customer history, they may determine, again, weighing the risk factor, may determine whether or not to determine that it's suspicious to file a SAR or not. Again, having filed that SAR, one of the things that the FIU would do is communicate with our stakeholder in the Customs and Excise Division in terms of to verify through the currency declaration if in fact, as well as immigration, if in fact the person have been doing that type of travel. And if that is the case, and based on the amount and so on, there are several factors that would weigh into it. Again, it may just be filed for intelligence at the FIU and not as information determining that someone may be laundering money or some offense, as the case may be. But it's filed for intelligence, and it ends there.
No, thank you very much for that. It's a source of some consternation. But as we're speaking on cash, in the submission, the FIU TT identified cash-based businesses as one method of money laundering. And just for the benefit of the public, can you explain what makes cash-based businesses more facilitative for money laundering as opposed to other types of transactions?
Right. To answer Member Bacchus, cash-based businesses is normally an international standard in terms of what one of the triggers for money laundering, persons involved in money laundering. The reason being, whatever illicit activity that someone may commit, if it is, for example, the sale of drugs, as the case may be, normally the payment is in cash. To get that cash into the system, which is part of someone trying to launder money, would include using different types of vehicles. Cash-based businesses would be one of such vehicles that they would use, where, again, cash in itself does not leave a trail, per se, that you can identify, as opposed to if it's a check or if it's a wire that you can trace from A to B, as the case may be. So if a business, for example, and just as the chair said, I'm not indicating any business is involved in any laundering, but cash-based business, for example, hardwares or those type of businesses that generally public, everyone would normally have cash and go and buy, purchase those sort of things. So those types of business would obviously have a high volume of cash. So those types of business are considered cash-based business, but again, based on the anti-money laundering regime in Trinidad and Tobago, the banks and they would know the example that I give for hardware X or hardware Y, the history, the amount, how much it's supposed to be as compared to hardware X or hardware Z, as the case may be, in making those kind of determinations. So it's a lot of risk approach that is used, as well as the history and understanding the transactions that the financial institutions see before making that type of response. But again, those type of businesses, and we all know those type of businesses that are cash-based because they normally accept cash.
There's just one, if I let's close it, please.
Tied up.
Yeah,
Okay.
that's the last piece. Cash-based businesses, cash-based events. That is the other one. So, again, to a hypothetical situation, I have in my big fete for Carnival, Christmas, whatever it is. One-off event, cash-based transaction, get receipts in cash, payments to artists in cash. And those things also occupying the attention and visibility of the FIU.
Thanks for the question, Member Bacchus. Interesting question. Yes, again, it comes back to the financial institution in terms of identifying and making that filing with the FIU. Once that is done, and again, that will also involve the Board of Inland Revenue in the sense of whether or not the proper amount of receipts are being reverted to the Board of Inland Revenue coming out of those type of businesses. I am aware in other jurisdictions, they actually have a competent authority dealing with revenue that actually attend some of those functions in terms of gate receipts on average, so that that is something that is done in other jurisdictions. But again, to answer Member Bacchus, yes, it's something that is engaging, and once that information comes to the FIU through the STRs that the banks are mandated to file, once they deem that the transactions are suspicious, that is something we would look at as well. Thank you.
In your submission to us, you stated that financial institutions and listed businesses are required under Regulation 7.2 of the Financial Obligation Regulations 2010 to conduct a risk assessment of their business, products, services, and customers. Tell me, sir, to what extent are financial institutions and listed businesses conducting these risk assessments? And has the FIUT observed an increasing level of compliance with this obligation in recent years? If you can tell me as succinctly as you can.
Yes, Chair. Again, it's a requirement within the financial regulations as we indicated. Not only the FIU-TT, but as well as TTSEC and Central Bank have that obligation when we conduct our examinations for AML-CFT to verify that there is documentation relative to risk approach being conducted by the entities on their customers. The FIU-TT have seen that. We have received and we do request from entities their risk-based approach policy document in terms of how they treat with risk for customers. Again, that is something that is throughout the reporting entities requirements. I would leave Central Bank or TTSEC to expand on that aspect of it further.
All right. Through the chair, we actually do a risk-based supervision of the entities. We have a specific unit. We have the manager, AML, and if I may defer, she may summarize exactly what is done in relation to the financial institutions. Nadira, could you assist?
Good morning, Chair. Good morning, members. I'll follow on what Mr. Stoddard indicated. The requirements are in law since, I believe, 2014, in fact. And at that point in time, the central bank would have issued, or in fact, we updated our AML guidelines, and in there, we articulated the expectations in terms of the financial institutions undertaking that risk assessment of the business and their business activities, their customers, etc. At that point in time, a gap analysis was done, and all the institutions under our supervision indicated that they have either conducted the assessment or that they were in the process of doing so. Now, going back to what the inspector said, in terms of monitoring for ongoing compliance, we do that through on-site examinations, and we also place reliance for off-site monitoring on external AML audits that are required to be conducted by every financial institution and listed businesses to ensure compliance with the requirements. So through that mechanism, we have been monitoring compliance with that particular requirement. So generally, based on our on-sites and the off-site monitoring, there is a good level of compliance with the requirement in terms of conducting those assessments on a periodic basis. Thank you.
We are comforted knowing that is happening.
Here now? Okay. Yes. Sticking with the issue of cash, you mentioned in your submission that because of the number of cash-intensive businesses we have, that you all are looking at a currency threshold reporting regime and to introduce something like that. Give us a brief synopsis of what you anticipate how this will work, currency threshold reporting, what exactly is the amendment you're seeking to have, and how far you've reached with that process in terms of currency threshold reporting.
Thank you for the question, Member Lachmidial. Just to be brief with the question, but to be succinct as well, FATF Recommendation 29 speaks to other forms of information that the FIU can have access to or should have access to. One of it is currency transaction reporting or threshold reporting, as the case may be, as well as wire transfer reporting. Most FIUs in the jurisdiction would have that type of, not only in the jurisdiction but outside, would have that type of reporting, of one type of it. That assists in the sense of STR reporting is really based on the compliance officers at the institution making that determination for a report. Currency transaction reporting, I think most persons who travel a lot or conduct transaction in the US and other jurisdictions know that once they conduct a transaction above in the US 10,000 or in Canada 10,000, Australia, automatically a currency transaction report is filed. Those currency transaction reports assist the FIU in the sense of not waiting for an STR to be filed, because an STR may not be filed on someone relative to transaction they are conducted. The FIU can act based on those currency transaction reporting to assist in determining whether ML base, again, comes back to the amount of transaction being conducted throughout a period of time as well. The FIU have sought, and we have started a policy document that would seek to introduce that type of reporting in Trinidad and Tobago. One, it would assist us with doing further analysis of transactions and to do further analysis in determining and assisting law enforcement and other authorities relative to money laundering and financing of terrorism. That is something that we have done the research of not only jurisdiction within the region as well as outside of the region, and the policy document has been formulated, and it would be out for discussion at the NAMLAC, again, to make sure that we capture and cover what we intend to look at. One of the issues, of course, would be the threshold amount, whether it's something similar to the US. If it's 10,000, what's the rate now, or if it's what's in the Proceeds of Crime Act as what the banks look at right now, which is $50,000. So those types of determination is to be finalized, but that is something that we could have ready or should be ready by first quarter in next year, roughly. So, like I said, we have done the research, and that is something we want to introduce into the system. Thank you, Chair.
Thanks very much for that. And just for clarification, would this currency transaction reporting, for the benefit of members of the public, because I know my phone is going to light up soon, people say, so every time I spend this amount of money, this is how much I'm going to have to file a report. But is it going to be just for the regulated entities when we conduct a transaction with bank, real estate, jewelry, cars, and that sort of thing, or is it going to be across the board, every business? Because you said the exact example that I'm thinking about, hardware or car parts businesses, things like that. People do spend cash, and they may from time to time spend quite a bit of cash. And could you also, while you're on that topic, touch on the cash threshold for a cash seizure by which the police can investigate if you're in possession over a certain amount of cash? Because I think that's also something that we have to take into account when you're looking at creating limits and a reporting threshold for cash, how much cash you're allowed to have without the police being able to seize it and to investigate you. I know it used to be 20,000. I don't know if that has changed.
Thank you, member, for the question. I will address the second question first. The 20,000 limit still stands. Of course, it has to be based on some reasonable grounds for suspicion in terms of the police officer acting relative to the seizure of that fund. So it's not a matter of if I have 20,000, automatically the police will just seize my my funds. On the second part, there's again based on the research, and I will ask my assistant legal officer Shivana Sharma to address it. The second part, there's in Jamaica right now they have what you call a currency threshold reporting requirement, and that requirement basically states that again there's a threshold limit. I'm not certain of the figure in Jamaican dollars right now. I think it's close to $1 million or something like that, but there's a limit that any person conducting a transaction above that amount must go to the financial institution to conduct the transaction. So in other words, you can't go to purchase with a certain amount above it must go through the financial institution. So what I'll do, I'll ask Shivana to expatiate on some of the research that we would have done and to address that question you asked, member.
Good morning, everyone. Good morning, Chair. Good morning, members. Just briefly in relation to the threshold reporting, our research and what we've developed so far is to focus on the FIs, transactions that involve financial institutions as well as listed businesses. We are still to confirm that as well. It is a policy paper. And in relation to the research, what we can do, if possible, provide that research or points on that the research that was done at a later date, please.
Is there any evidence which indicates a link between suspicious financial transaction and overseas international organized crime groups? Have you really found anything?
Thank you, member. Thank you, Chair, sorry, for the question. Definitely there is a link. Crime or proceeds of crime or crime conducted in Trinidad and Tobago is cross-border aspect of it. One, whether it's the commodity that is being used, whether it's drugs, whether it's human trafficking, it may come from outside of Trinidad and Tobago into Trinidad and Tobago, as well as the funds may be repatriated outside of Trinidad and Tobago as well. So there is definitely a transnational link in terms of organized crime that would be in terms of that link as you had mentioned.
Evidence?
Well, Chair, based on media reports, we would have seen persons being extradited, persons being arrested, persons with links in foreign jurisdictions as well. So there is that aspect of it in terms of evidence that there is a relationship in terms of illicit activities here and the illicit financial flows of funds in other jurisdictions as well.
I could.
Go ahead.
Okay. As you're on the foreign component on this, obviously FIUs have relationships rather than foreign entities and so on. And it was highlighted that for the reporting period ending the 30th September 2023, that the FIU received 7 requests from foreign FIUs for permission to share, et cetera, et cetera. With how this was going, what were the predicate offenses, linked to these cases, and did the FIU comply with the requests for this? This is about collaboration and you working with your international partners, if this is something you can share.
Thank you for the question, Member Bacchus. Yes, you're correct. The FIU is a member of the Egmont Financial Intelligence Group. Currently, there's 177 members within that group, and we do exchange information on a secure platform amongst each other. Being a member of it, we are required by the articles within the membership to provide intelligence and assistance to FIUs once requests are made. And it's similar to when Trinidad and Tobago make a request as well to a foreign FIU. So those requests, I can't speak for the exact criminal conduct, but it would be related to money laundering, tax as well, and drug trafficking as well. So those requests are normal requests that would be made and would be responded to assist.
In your submission, you stated that a total of 10 intelligence reports were forwarded to the Board of Inland Revenue on individuals and or businesses for further investigations. Can you briefly indicate the main types of adverse conduct that the FIUT would report to the BIR? And how would you describe the current level of cooperation received from the BIR?
Thank you, Chair, for the question. The level of cooperation with the BIR is appropriate. Of course, there are restrictions in terms of legislation that would restrict some level of activity. Mm-hmm. However, the FIU is part of what is called a law enforcement working group, which comes under the NAMLAC, the National Anti-Money Laundering Committee, which BIR, the Board of Inland Revenue, is a member, and matters are discussed at that level in terms of proceeding matters to some level of fruition. The reports that we would have sent, those 10 reports that we would have sent to the Board of Inland Revenue, are related to Again, it's suspected. It's not confirmed cases of tax evasion per se, or cheating the public purse. It's again coming out of what the financial institutions would have reported relative to what they would have seen, what they consider commingling, so to speak. All right, so those reports, once it meets that standard of for further investigation, it's sent to the Board of Inland Revenue for they to conduct the necessary investigations into that type of activity, as the records, as they are the holders of the records in terms of the persons who would have been reported to them. Thank you, Chair.
Thank you. So all in all, you're happy with your relationship?
Like any relationship, Chair, like any relationship, Chair, there's always room for improvement, and we are working together with the Board of Inland Revenue, as we do with Customs as well as Immigration, Central Bank. We all realize that the fight against money laundering is not a single entity. And so that collaboration is necessary because it touches all aspects of the competent authorities, as you can see, when someone is committing crimes, and especially if it's organized, as the case may be.
I can engage you on not every relationship, because there are some relationships that are very, very good. I'll pass you across to my friend. You talk about that after.
Just quickly, Chair. You talk about the collaboration between the agencies, but what has been the success of these collaborations? What is the success in this relationship between all of these units in terms of convictions? Because there's a feeling by the man on the ground that all we have when money laundering and anti-terrorism and so on is just old talk. Nobody gets arrested for money laundering, nobody gets convicted. Nobody goes to jail for money laundering. Or anti-terrorism. So what is the success rate in terms of the collaboration between FIU, Inland Revenue, Comptroller of Customs and Excise, Chief Immigration, Central Bank? What's the success rate? Or how do you measure your success as an entity?
And to see what you can do in addressing his question, could you also relate to the credit unions, tie them all together?
Mr. Stoddard, perhaps you could. Chairman, I forgot to declare my interest, but I used to work at the FIU, so I just sort of thinking. But Mr. Stoddard, could you just also explain the feedback reports from law enforcement agencies, please, and address that issue? I think that would be helpful.
Thank you for your question, Member Hislop, as well as Member Ramdiel. Right, so in terms of the success or what we consider as the question was posed, I would respond by saying in fourth wrong mutual evaluation, when Trinidad and Tobago was assessed, at that time we had 2 money laundering charges. And at that time, of course, it was not considered sufficient by the assessors, and we were it was determined to be a deficiency. Since then, resources would have been put into the FIU as well as the TTPS, in particular the Financial Investigation Branch, who is responsible for investigating money laundering. And at this point in time, or for the last period, how much it was? Right. There is over 140 money laundering charges. Charges?
Yeah,
Yes, charges before the courts. Again, like I said, the system is that it's not one entity that is solely responsible. It's a chain of events. So we would have provided information or intelligence to law enforcement to assist them in their investigations. Once requests are made or once we send information to them, to assist them in the charges. So they would have conducted those charges, made those arrests and charged persons, and at this time, matters are before the court. I know that I can't speak to the exact amount in terms of being completed. I think it may be 5 if I'm not mistaken, but the vast majority are still before the courts to make that determination relative to the number of persons charged. In addition to which, the FIU would have assisted the central bank, the TTSEC, in terms of when they are conducting their compliance examination with information relative to STRs, the number of STRs, the quality of STRs that would have been reported to ensure that when they are conducting their examination, that the entity is in compliance. We would have the FIU again in terms of when we say successes, it's not publicized to the extent as it is, but we do publish our alerts, advisories relative to any trends that we would have seen, considering, for example, investment scams, loan frauds. We would have published strategic analysis reports, the last one being illegal wildlife trade, with recommendations that could assist the Ministry of Agriculture and Fisheries. So the FIU is assisting competent authorities, not only locally but internationally, with their remit, so to speak. It's something that is the FIUs normally publicize in terms of the work that they're doing, especially if matters are not completed. In the past, it has been done internationally where matters have been completed, and the FIU would have been, FIU-TT in Trinidad would have been recognized for the assistance as well as the cooperation that would have been extended in those matters. In addition, just briefly again, we do publicize guidance, we do outreach sessions to the entities, and all these contribute to ensuring that the entities are aware of their AML CFT obligations, that they could protect themselves against money laundering, as well as terrorist financing. We have taken a more stringent approach in the sense of NPOs to bring them up to date, to make them more aware of their risk to financing of terrorism. So those are some of the areas that the FIU we would consider as being success. Of course, all those areas that I would have mentioned and more are the functions of the FIU in which we would have been assessed on in the last mutual evaluation. Just to say that relative to recommendation 29 of the FATF, the FIU in Trinidad and Tobago is currently rated as compliant with FATF recommendation 29. I think if, right, feedback. Thank you very much. Feedback is something that is very critical and crucial to the FIU because it guides the FIU in terms of the information we provide, how useful it is, how we can further assist law enforcement if there are gaps. So relative to that, we are getting feedback from law enforcement. We have embarked on an exercise with the Financial Investigation Branch to for they to go back into their records and where they would not have provided feedback to provide that level of feedback. We have also met with the law enforcement authorities one-on-one, discussing areas of feedback where we can assist. And for instance, one of the examples is with the Board of Inland Revenue. They would have indicated what type of information they may need or further information they may need to assist them in their investigation, and we would have amended our procedures to accommodate those types of feedback. Thank you.
Thank you, Chair. Through you, Chair, Mr. Stoddard, we're sticking with relationships, and we want to talk a little bit about the credit unions and the relationship between the FIU and the credit unions. You mentioned about some challenges and low level of responses, but it seems like you want a divorce because you said that when part of your submission, you said that the regulation of credit union submitted that consideration should be given to placing AML CFT supervision for that sector in the hands of the prudential regulator, which is the Commissioner for Cooperative Development. Now, we actually had representatives of the credit union sector here on another inquiry, and the topic of regulation and anti-money laundering and so on came up. And going into the 5th round of mutual evaluations, are you satisfied with the level of oversight and regulation for the credit union sector? Are you satisfied with the responses that you are getting and from them in terms of when you identify deficiencies? And, well, I'll get to my other question, but it has to do with the Commissioner of Cooperative Development and your relationship with them. But if we could deal with that going into our 5th round and how we will be assessed and how that sector can be assessed, are you, what are some of the challenges you're having, and are you satisfied with the level of responses you're getting and your regulatory power and oversight with respect to them right now?
Thank you, member, for that question. I would try to answer it as best as I can in terms of the question. The relationship with the FIU and the credit unions, from the FIU perspective, it's a very cordial and cooperative experience. We do encourage. We have sessions with the credit unions, outreach sessions in terms of the obligations. One of it in particular, we would have, to make it simpler for the credit unions to comply with some of their obligations. We, in terms of what we call the quarterly terrorist reports, which is a monthly report that they are required, a quarterly, report that they are required to file with the FIU. We would have noticed that there was some deficiencies relative to the filing of those reports. We would have created an online system so that it's now rolled out in terms of an online system for them to file. So the filing has basically, I would say, 99% complete, or 99-point-something% complete in terms of when they're filing now. We would have done an outreach session to show them how to do it as well, in terms of that aspect of it. Further, we would have done, in collaboration with the UN, I think, we would have done the terrorist search, the targeted financial sanction. We would have created a search tool because, again, we would have gotten some feedback from the credit union sector as well as other listed businesses in the difficulty they had with the PDF version that we would have publicized by law. We have created a sanction search tool where it now is quite simple for the entities to access that information. So again, that is something that the credit union, they have access to and they are utilizing. In terms of the supervision part of it, again, it's a work in progress because like listed businesses, it's something, I wouldn't say new, but it's something that they were not doing before or mainly doing before. It's something that when you talk AML, CFT, it's really financial institutions who are the mainstay and have all the expertise and resources to fully comply with that aspect of it. However, we do adopt a risk-based approach when it comes to credit unions, and in terms of our examination and feedback. Once the examination is conducted, we do give them feedback relative to what deficiencies we would have identified, and we do give time frames as such. Where there are breaches that have been identified, and if there's a process that we have in place for enforcement, and once it elevates to another level in terms of the response, or if we haven't gotten a response, then it elevates another level, and we have taken action relative to that against certain credit unions. And again, one, in taking action to have them comply, we do extend assistance to them in ensuring that they are complying. So it's not an immediate action to sanction, so to speak, credit unions, but one, for them to understand their obligation and to comply with it, and where, like I said, sanctions do take place, we have had compliance relative to that from the credit union sector. But it's something, again, that can be improved because you have a spectrum of credit unions from large to medium to very small credit unions, but nevertheless they are considered financial institutions because they are receiving persons' funds and investing in whatever activities they may be. In terms of, sure.
Let me then, based on what you said, let me just refine the question. They are treated as financial institutions because, as you said, there's some of them who have an asset base probably larger than some of the non-bank financial institutions being regulated by the central bank. And then there are also very small ones, but at the end of the day, they're dealing with money. They're taking deposits, they're lending money, and so on. Do you feel that the Office of the Commissioner for Cooperative Development, and when we had entities here before and we were speaking to them, we got the sense that their role as a regulator didn't really focus on the propriety of how credit unions were doing business on AML, CFT at all, and that there was a total lack of expertise and understanding in that particular division. Would it not be, do you think that they are a capable AML, CFT supervisor? So that's my first question. The second thing is, do you see it as an inherent weakness in as a country, our national AML, CFT architecture, legislative architecture, that we haven't passed the credit union bill and that we haven't gotten a serious piece of legislation to regulate credit unions, not just on the prudential side, but also in terms of AML, CFT? Do you see that as a weakness for us as a country going into the fifth round mutual evaluation?
You answer. I want to add something to that. The last time when you all appeared before us, I raised some concerns about the know your customer requirements. And you spoke about cordial and cooperative relationship with the credit unions. And what I'd like you to do, sir, is to explain, when you're dealing with the credit unions, what is required in terms of knowing your customer, so that you don't have to answer some strange questions when you have a bank slip and you bring a check from the bank, that you still have to explain, where did that money come from once it's over a certain amount. If you have everything to show where the origin of the money, train them to understand that what is required is nothing else.
Thank you, Chair, for that question. Right. The aspect of supervision or prudential, so to speak, regulator for the credit unions, again, that is a bit outside of my remit. I know that it's a requirement in the, as you said, they are financial institutions. I know that there are some policy paper that is probably being worked on right now relative to having a supervisor for the credit unions. I'm not familiar to the extent of the authority of the Commissioner of Cooperative or the authority relative to credit unions, how they regulate them. I'm not totally familiar with their functions along those lines. That is, if it's something similar to the central bank or TTSEC. But definitely, from my understanding, whatever, because the bill, there was a bill and then it lapsed and then there was another bill and so I understand that they are going into a different regime in terms of supervision. So once that policy paper or that thing comes to us for any type of comments, we would then give our having read the document, our comments relative to that aspect of it. Going into the fifth round, again, it's based on risk. I can't determine what the assessors would look at or make a determination. But in terms of the AML supervision aspect of it, we are doing that on a risk-based approach and trying to meet all the requirements that the credit unions are supposed to meet, and in terms of our supervision of them. As you rightly said, I know, and that was before my time, in terms of the 2014, I know that bill would have been, I think it would have been for the central bank to supervise, if I'm not mistaken, at that time, right? So, like I said, there are certain reiterations, and the latest appears to be that a body would be created for that level of prudential supervision. In terms of the AML, as you said right now, in terms of their expertise for AML, they do not have it, and as such, for the time being, the FIU TT is the supervisory authority for anti-money laundering and counter-financing of terrorism. For best practice in terms of supervision for AML, the best practice normally is that if the prudential regulator is the prudential regulator for a sector, that the AML aspect should also be within that prudential regulator, similar to central bank and TTSEC, as opposed to having it separate and outside of it, where you would have more levels of for collaboration and cooperation, which is not within one house, so to speak. So that is something that...
sorry, just take a bit. So in terms of the new policy you're speaking about of creating a separate body as a prudential regulator, your recommendation, and I don't know if you could speak for the National Anti-Money Laundering Committee, but the recommendation perhaps should or may most likely be that that body that is going to be created will also take over AML supervision, or are you, you know, how...
Again, I haven't seen the document in terms of what the outline is. Again, if that is the scenario, of course, there must be capacity building, and if the FIU is required to assist with the capacity building for a period of time, that is something that would have to happen, because again, you want to ensure that the sector is properly regulated and so on. So it's not a matter of leaving them on their own, so to speak, but the FIU would assist. I'm assuming that a sunset clause could be added as such. But like I said, I haven't seen the policy, so I'm not certain what it entails. To answer the chairman's question, Chair, I hear your frustration in the response, and I agree with what you would have indicated. We have been reaching out, and we have been giving that type of guidance, but it comes back again to the entity in terms of their risk appetite, their requirements for CDD. The legislation does outline what it requires, but it also gives the entity, whether it's credit union, the bank, or anyone else who is a regulated entity, it does give them a caveat, so to speak, as to indicate or to add any other system that they feel may be necessary for them to address their risk appetite for against money laundering, as the case may be.
It really boils down to a matter of common sense, definitely, which is not always so common. I'd like Mr. Dinobriga to come in here. He could have spent, I suppose, the whole day with you, sir. But there's so much information. But we do have to engage the other entities, and Mr. Dinobriga has to go elsewhere. We have other business to conduct, and I'm conscious that you also have to eat. So let's.
Thank you. Thank you very much, Chair. Director Stoddard, coming off of credit unions, but I would like to talk about the non-profits and what the FIU's role in terms of regulating in that sector. In your submissions, you spoke about a variation to the, I think it's recommendation 8, the FATF recommendation 8. From the outline you've given here, it seems as if the sector's participation is largely voluntary. So as you're conducting the revision, what I wanted to know, so as you've said here, right, you're working alongside the World Bank and embarking on an updated risk assessment in the sector with a view to revising the legislative obligations and to make it more congruent with the risks in the jurisdiction and the revised FATF recommendation 8. One, how far along are you all with the risk assessment exercise? 2, when is the updated exercise expected to be completed? But 3, because you've outlined it the way you have, I just want to get an idea of what has the participation, the uptake and the compliance been like in the sector?
Thank you very much for that question, member. Right, you're correct in that the World Bank is assisting as well as the EU Global Forum relative to the non-profit organization sector. I'm pleased to say the risk assessment for the NPO is a standalone assessment as opposed to the national risk assessment that is being conducted throughout the sector. It's a standalone module, so to speak, so it's done on its own. The team that is charged under the national, under NAMLAC, have basically completed the risk assessment of the NPO sector. The report is being finalized at this stage. Once it's finalized, it would be going to the cabinet for their information and decision. Just to indicate, Member Dinobriga, the NPO sector, since the submission, there's a lot of changes that would have taken place. One, in terms of FATF, where the unintended consequences that were being placed on NPOs to class them with the listed business sector with the same requirements, FATF would have realized that it stifled the actual operations of NPOs worldwide. So they would have changed their standard to now reflect that not regulation or supervision of the sector when it comes to the risks of terrorist financing, but to oversight, which is even a lighter touch in terms of the now oversight of the NPO sector. So the requirements to have what the chair would have described in terms of source of funds and all those requirements, FATF is no longer looking at those type of requirements for the NPO sector. So there's a different level of oversight that would be afforded to that sector. The other question in terms of the relationship with the sector, we have had several meetings, and we continue. Again, part of the requirement, because in the fourth round we would have gotten a non-compliant for recommendation 8, and after the review of the third follow-up report, we would have gotten partially compliant. So a lot of work have been done in that area to ensure that legislation is one. There are changes, and there's legislation that would be before the Senate as well shortly, dealing with that aspect of it. That would assist as well. Right. So the participation of the NPOs, they are, again, just as different sectors, you have the larger ones, medium and small, and we are reaching out to all. We have the assistance of other larger NPOs who would have been part of the EU Global Facility training as well, and they would have participated in that aspect. So we are using that avenue for them to assist us in reaching out to the smaller credit unions, NPOs as well. So that is in train right now. If you look at our annual report, our last annual report, out of the 30 sessions that we would have had outreach, the NPO sector would have benefited almost half thereabouts of the sessions that we would have done. So there's a concerted effort to bring them on board in terms of their abuse or possible abuse for terrorist financing. But again, in terms of the the oversight aspect of it, it's going to be on a more lighter scale in terms of dealing with those sectors, just as to not to disrupt the vital role that they play when there are disasters and social needs and so on. Because again, you don't want to be going to make a contribution or donation to NPO and being asked, what's your source of fund, how much ID you need to have, and all the different aspects that goes with the normal AML CFT supervision.
Thank you very much, Mr. Stoddard. We've really exhausted you. You've earned your salary for 25 as well. We're not quite finished with you, though. So what we will be doing is submitting to you for your feedback some specific questions, and we'll take them in writing. Even to go into the number of questions we have here for you will take some time, and we really need to hear from another entity now. So I must thank you for your very measured and thorough responses, but let's have Central Bank on the table now.
Thank you, Chair.
Hislop, I think you were the first one.
Thank you, Chair. Just a couple questions I want to pose at the start. In this submission, it was noted with respect to counterfeit currency that dealing in foreign currency without authorization is an offense. I think we touched on it earlier.
Yeah.
We just want to find which entity is responsible for verifying that unlicensed dealers are trading in foreign currency.
Which license? Could you repeat the
Which
question?
entity is responsible for verifying that unlicensed dealers are trading in foreign currency?
Well, we have a list of authorized dealers, right? And the authorized dealers are published on the website, and it's essentially the commercial banks and the certain bureaus. These are the authorized dealers. But if there is a situation where unauthorized people are dealing with it, if the information is brought to our attention, we refer the matter to the TTPS for investigation, and then in turn they refer it to the Director of Public Prosecution to see if there's a case to be made.
Okay. But we're dealing with with money laundering and counterterrorism financing. I think the average citizen knows that there is a significant amount of foreign currency floating around. Do you see it as a threat in terms of the money laundering issue and terrorism, financing of terrorism? Do you see it as a threat to that foreign currency that is floating around? Do you see that as a threat? And could you, as a central bank, speak to something like that?
Obviously, if it is being used for illegal activities, it is a threat. All right, and I will defer to my deputy to add to the discussion.
Good morning, Madam Chair. Good morning, members. With respect to FX transactions, only authorized dealers, as you know, are expected to deal with forex currency. Whether there may be illicit activity going on there, but it's to detect the illicit activity, right? So once it's detected, as the inspector would have indicated, where there's illicit activity is detected, the TTPS is the entity that will investigate at the current moment. They are the entity. To the extent it may involve information that the central bank may be required to provide to assist the TTPS in its investigations, the central bank will do so. But to quantify how much illicit activity is going on in FX, we don't know. I wouldn't be able to say. So our focus will be on authorizing, making sure that we publish the list of authorized entities on an annual basis to advise persons that these are the entities with which they should do business if they have to deal in foreign currency. So that has been our focus.
Okay. Just a final question, Chair. You stated, this is the central bank, your submission stated, while the FIU TT's figures on counterfeit currency may be a subset of what exists, overall the central bank has observed a decline in counterfeit currency since the introduction of the polymer notes. Now you could provide this information, I think it's you could provide this information in writing to the committee. The actual number of reports made to the CBTT from financial institutions regarding these institutions' receipts of counterfeit currency between 2018 and 2023, the total value of counterfeit bills, notes reported to the central bank, and the number of physical bills, notes involved. And that is something that you can, and we want to commend it from the standpoint that since the introduction of the polymer notes, there has been a reduction in in the counterfeit. Yeah. So we want to commend the central bank for that. But just to finish with me, Chair, all these entities, all of you all before us, treat with the focus that we're on today is counterterrorism and money laundering. But how this organized crime of money laundering and terrorism operates really and truly outside of the formal sector, and your responsibility is regulating, more often than not, regulating the formal sector. Do you see that as being a challenge, and do you think that the entities are really capturing all the necessary data that's required to treat with these activities? I don't know who will jump in first. I guess Central Bank.
I would start off, Member Hislop. Just a bit of a correction. Actually, the money laundering and the financing of terrorism do play a large part in the formal system in terms of banks or insurance companies or all the different regulated entities. So because of the very nature of it, they need to transfer, transact, and they need those systems to do those type of activities. There would be, of course, some level of informal activities, and those type of activities, the intelligence agency or even the law enforcement agency would have some level of information relative to that. And again, those types of information are shared with the FIU as well, to assist, again, they in their intelligence or investigation of those type of informal systems. So just to indicate that the reporting entities do have those obligations, which they do report, hence the reason why you do have those levels of reporting, as well as where they deny transactions based on what systems they have in place. So there is I won't say a delicate balance, but the criminal entities need to use the formal system, and the majority of it is through the formal system, where someone, for instance, may be using, let's say, cash across a border. Again, there are systems in place to identify that or to track that, or law enforcement or intelligence to try to stop that type of activity. And it do happen from time to time, but again, no system is 100% perfect in terms of those type of illicit activities, because it is always a change and an innovative way of trying to subvert the formal system, right? But the system that is in place is similar to any other jurisdiction, because we all follow the same international standards in terms of having the different systems in place. So it's an international standard that we do follow in terms of treating with money laundering and financing of terrorism. Thank you.
The submission from the central bank. Sorry? Oh. Somebody, all right, sure, go ahead. The floor is yours, Mr. Solomon. Oh.
Mr. Guy.
Miguel.
Thank you, members. Just to add to what Nigel started, if you start from a national risk assessment, it maps all the activities within the jurisdiction, whether it's formal or informal. And so some of the listed entities that Nigel would have responsibility for, if you're trying to utilize illicit funds, what would you do with it? You probably go to a pawn shop and things like that. Those would be covered, where they have to provide certain reports and they are trained and so on. So the long and short is, if I look at all the business activities within a jurisdiction, they are classified and placed under one of the competent regulators who will, for money laundering purposes, have oversight.
So just a follow-up. So very quickly, so why is there still such a vibrant informal foreign currency trade? I can't get, this average citizen struggles to get currency from the bank, but you could get almost any amount outside of the formal system. So if I understand there's a very delicate balance in that, but why is it? Is it that it requires more rigorous legislation and rigorous monitoring, and so I can't get, the citizen can't get $1,000 US at the formal exchange, the legal foreign exchange dealers, but I could get more than $1,000 US outside of the legal dealer.
That's a difficult question, but however, what you can say is that the financial institutions have robust systems to detect, prevent, and report issues. So if they decided to try to put these illicit funds that they derive from the foreign exchange into the bank will block them. So obviously, it will be outside of the formal system. So that is to answer your question. It gives you an idea that the systems in place in the banks are robust and prevent the detection. They allow the detection and prevention. So it will not come into the formal system. It will be in the informal system. And therefore, that is for the TTPS and other people to investigate. But I'll put the answer over to Nadira, who handles this particular area, to add some comments to it as well.
Thank you, Inspector. But actually, I think Inspector was quite clear in his response. The remit of the central bank, it extends only over the regulated entities. So to pronounce on what is happening and what is driving that market in the informal sector is well beyond my remit. But but I will say, Mr. Guy alluded to the national risk assessment that is being completed right now. So I think that may shed some light. I don't know. We'll wait for that official report to be published.
In addition to Member Hislop, one of the areas when it comes to the informal aspect of it is that information is key, and it may require persons having that confidence to make those types of reports, so to speak, to the relevant law enforcement authority, because for they to know they have to get the information. But again, that is just an additional.
They're willing to pay $10 for 1 year.
Just Chair, through you, could we move on with the central bank on this question? Yes. Before we move on, just a comment though. I think we all wait with bated breath for that legislation that would better regulate the exchange control, because I think it ties back to that first conversation and that first question we had. You can't regulate what is outside, and if nothing touches the formal system and you're only regulating the formal system, I think the capacity and the types of offenses you create under the law is the only way that you can really deal with the informal system. So I think that's just a comment. I want to get into another area that we see as a potential weakness for money laundering, and that is the regulation of money lenders in Trinidad and Tobago. The 1932 Money Lenders Act obviously did not anticipate money laundering and terrorist financing, and this remains. I see people coming to the magistrates court and still getting their money lender's license renewed. I also see them every Friday morning in the petty civil court, taking up the whole morning, bringing people up who haven't been paying according and so on. And it's a very cash-intensive industry and lucrative business, especially in rural areas of Trinidad and Tobago. So, in the last national risk assessment that we conducted in, maybe that was what, 2014 or 15, how have we addressed the risk identified? Well, what was the risk? If you could share for the benefit of the whole committee, what was the risk identified for this particular sector? Was it addressed? What have we done since then? And do you anticipate any legislative changes and increased regulatory oversight for the people who are continuing to conduct business as money lenders? Because they are, it's a very, again, cash intensive, which we've already admitted is a high risk area of activity. Questions for Central Bank and perhaps FIU.
Okay, I'll defer to Nadira, who was part of the risk assessment.
Thank you. You're very right, member. That is an area that is occupying our attention. As a matter of fact, the last risk assessment flagged it as an area of emerging risk, but it did not actually conduct the assessment at that point in time. So coming out of the current national risk assessment, there is a separate standalone assessment being done currently of the sector to assess the level of risk, the level of exposure posed by the sector as it is, as you rightly said, unregulated at this point in time. So the outcomes of that assessment will inform regulatory reform based, again, on the nature of the risk, because you rightly pointed out, it's very prevalent, especially in rural areas, so targeting primarily vulnerable groups who may not potentially be able to qualify for a loan through a bank. So right now that work is ongoing, and we look forward to the outcome of that particular assessment.
Tell me, has the Central Bank reviewed the Electronic Transactions Act passed by the Parliament in 2011 to determine whether that act would adequately address gaps as stated by your submission regarding digital signatures and digital identity? Central Bank?
Nadira, you want to help me with that as well?
We are oh, sorry, Chair?
Okay, she's responding.
We are considering the impact of the Act, particularly as we move towards more electronic payments, as you rightfully mentioned, and what we're also seeing in the sectors is the adoption of more digital onboarding solutions. So it is something that is under consideration right now, and there are certain unproclaimed sections of the Act, particularly that would really inform how we move forward, and it's something we have been advocating for in terms of proclamation of those particular sections, together with certain sections under the DPA as well, because they go hand in hand.
Have you been communicating with the AG's office or what?
It is the three supervisors for AML, from an AML perspective. I'll speak to this from an AML perspective. The three supervisors, the supervisory working group of the NAMLAC, have been considering that, and through the forum of the NAMLAC and the AG's role as a member, there will be that collaboration, particularly with the legislative drafters in the AG's office, to the extent that changes need to be made, or whether we advocate for proclamation, as I said, of those unproclaimed sections.
All right. Now, your submission identified 4 gaps in the existing legislative framework: administrative monetary fines for AML, CFT breaches, virtual assets and virtual asset service providers, digital signatures, and digital identity and money lenders. And there's currently no regulatory framework to treat with virtual assets and virtual asset service providers. So what efforts have you all made to advocate for the modification of the regulatory framework for treating with virtual assets?
Again, I'll defer to Nadira. This is her area of expertise.
Yes, batting in your crease, eh?
Thank you, Chair. I'm not so certain about whether it's an area of expertise, but it is something that we are actively looking at. And again, as part of the NAMLAC and the supervisory working group, the 3 supervisors are undertaking a risk assessment again to understand the level of activity and the number of players in the market and what that looks like to determine the level of exposure posed to the country. This work is very important because under the FATF standards, there's one particular requirement that we need to address in terms of being compliant with the standards. So that is occupying our time right now as well, particularly as we move forward into 5th round mutual evaluation.
Yeah. Just as we were dealing with money lenders and other pieces of that, in the submission it was noted, and this is the central bank submission, that the significant activity and growing and increased advertising in the print and social media of large sums of unsecured cash loans. And this was being observed. Does the central bank look at this as an issue? Because it's almost like having unregulated money lenders, if you want to put it that way. Do you view this as an issue, and is there any action that the central bank thinks needs to be done as it relates to, and everybody sees them, we've seen them all the time.
Yes. Again, we see it as a particular issue, but you only could regulate if you have the powers to do so. So what we are doing, again, is as part of the risk assessment and as part of the cooperation between the various supervisors, coming up with ways to identify the risk and how to mitigate what sort of controls you would put in place. But unless you have relevant legislation in place, enforcement is really difficult. It's outside of our purview. But we recognize that it could have an impact in terms of the effectiveness of illicit activity taking place in the country.
Last one, Chair. So a lot of what you're doing is built around formal levels of collaboration and informal levels of collaboration as well. Mm-hmm. And so it is within that framework that you're able to make all of this work.
Right. That's the only way it's possible to do, because, again, if you tread outside of your powers, you have no enforcement ability to do anything about it. So what you do is, part of your risk assessment, you identify areas of vulnerabilities, and then you come up with the various regulators to decide what you can do. But an essential part of it is getting the support of the legislators as well. Because what happens internationally, a number of standards are put in place, but they are not necessarily enforceable in the local jurisdiction. So we have to amend the legislation in order for it to be put in place and therefore to be enforced going forward. So we recognize the vulnerabilities, and we've been working together as a group in order to deal with that issue.
Thank you. Thank you, Chair. It's a happy marriage where there is still some work to be done.
Yes,
to
definitely.
allow for all the things to come to it, for you to be able to enforce the pieces that you identify as risk.
Yeah.
Depending on how you make it. Thank you.
Thank you.
Thanks, Chair.
We move on to Trinidad and Tobago Securities and Exchange Commission, TTSEC.
Yes.
And really, it goes right from where we were with the other entity, because the first item is the legislation. page 1 of your submission, you highlighted that the sector's vulnerability to money laundering is influenced by factors relating to the strengths of controls within its legislative and supervisory framework instituted to manage risk in these institutions, supervision procedures, availability and enforceability of administrative sanctions, and the compliance function, as well as inherent factors specific to institutions in the sector, the size, the complexity, client base, liquidity of the portfolio. What were the legislative gaps identified from the National Risk Assessment with respect to money laundering and terrorist financing?
Okay, so thank you, Madam Chair and colleagues. This is an ideal example of the level of collaboration that we have, because together we would look at the standards, the standard set, and we would assess whether or not as a jurisdiction all the areas or the sectors are meeting the standards. We will roll out those standards to them. One that was recently addressed would have been penalties and enforcement of money laundering breaches. So that, was it passed?
No.
Where is that?
No, it's in the Senate.
It's, so Nigel just given me some guidance that the matter is before the Senate now. So that hopefully soon we'll be able to say that we have satisfied that. But issues like that aren't unique to the TTSEC. It's across the regulatory bodies. Madam Chair, we just spoke to the regulation of virtual assets, for instance. That continues to be a challenge to the jurisdiction. While we have been, Nadira alluded to the fact that we've been working on some policy stance to give guidance to the policymakers as to what might be appropriate. These are the processes that must be followed for us to arrive at a conclusion. So these are some examples.
All right. Well, we do have a debate coming up in Parliament soon, so we have to stay away from going into the specifics. Yes. Anticipation. Your submission stated 15 registrants, or 28% of registrants, were found to have deficiencies in the area of transaction monitoring, customer due diligence, compliance officer requirements, and compliance program requirements. And there also you identified deficiency in reporting to the FIU TT for 77% of registrants. So what strategies have TTSEC implemented to encourage a greater level of compliance among registrants or entities? And what targets has the TSEC set in terms of achieving a greater level of compliance among entities in the securities sector? 10% or so over the next 2 years? What do you have in mind?
100%. We want full compliance. So that's the starting point.
And you are really realistic fellow.
I am, because we have a program that we set out, we roll out, we provide guidance, whether it's through circulars, guidelines that we expect entities to follow, and even if it's new legislation that we're putting in place. Once we establish those, we engage with the entities, and my colleague Rosalind and her team will go and conduct compliance reviews to ensure that these entities are consistently doing what they're supposed to do. When there are gaps, we agree with them on time frames to correct these gaps. And where there are breaches, then we defer to higher enforcement actions, which we have the authority to undertake. Nobody wants to be threatened, so we believe that we can get a higher level of compliance once we continue to remain consistent with our program. In reference to deficiencies reported by FIU-TT, entities were not probably filing certain types of reports in accurate, timely, comprehensive manner. So we have undertaken sessions with FIU-TT to provide guidance to these entities on what is the appropriate way to complete these submissions so that they provide the relevant intelligence to the FIU-TT for the undertaking of their work.
Your strategy is gentle persuasion, that's it?
Well, moral persuasion is our first line of strategy, and then we are backed by further enforcement powers, based on a ladder of intervention, where we can find penalties up to various amounts and suspension and revocation of licenses.
And you have exercised those powers, the last two that you spoke about?
Let's say our persuasive elements have been working well.
I see. I see. Well, I hope they're listening and knowing that, you know, the big stick is coming after. All right.
Good morning again. Well, no, it's afternoon now, I think. Yeah. Afternoon now.
Good
I want to ask about a little bit about the on-site inspection program, but before that, you know, we just talked about with the central bank not being able to regulate what you, or, you know, outside of the formal sector. But TTSEC and under the securities law, you all have market surveillance.
Yes.
And that's part of your mandate, and you have a division that conducts market surveillance. And if there's a lot of potential money laundering risk when it comes to persons offering, because a security is a very wide definition of what is a security. And there's a lot of risk involved with people who might be operating and offering products and investment opportunities and schemes, we call them pyramid schemes, and so on, to people. And they are outside of your remit, they're not one of your registrants. But part of your mandate is to monitor the market and to pick up on these things. So if you could just touch a little bit on your work in terms of market surveillance to root out these areas of risk for money laundering, because apart from the fraud aspect that could be committed by these persons against unknowing members of the public, there's also a high risk for money laundering through these types of unregulated, unregistered, unscrupulous characters who might be out there conducting securities type transactions.
Yes, thanks. Yes, member. So firstly, on just a quick point as it relates to pyramid schemes and so on, those have been since brought under purview, and we do have the powers to, right. Oh, I thought I misunderstood you then. Okay, so that's the first thing. But yes, we do have a strong surveillance team. Every day we have persons doing market surveillance of various type to be able to determine whether or not persons are doing any of the manipulation aspects of securities activities, or whether persons are offering things, whether through social media or any other platform, that can present itself as a form of security. I think in our submission we gave some broad numbers of the types of things that we would refer to enforcement and so on if we deem that something is inappropriate or something is in breach of some sort. I think one of those numbers was about 129 done in the last fiscal year, and we got up to about we reported about 103 for this fiscal year. That's from October 23 to September 24. That number has been since updated because at the time of this submission, it was about July or so that is about 159. So we do actually have our surveillance team tracking all of those issues, undertaking the relevant investigations as needed, and if we need to then further engage with TTPS, then we also undertake that activity.
Have you, in recent times, referred any matters for breaches of the Security Acts to the TTPS for criminal action?
We have a strong collaboration with the TTPS. Why I put it like that is because when we look at matters, yes, we defer to the TTPS on several issues. I think Patrick, for instance, outlined once TTPS undertakes its work, a recommendation goes to DPP and so on. So from the time the TTPS takes over, we will have a backseat to yeah.
Now, in terms of your regulated entities now and on-site inspections, Director,
Sure.
I want to answer this question. Could you tell us a little bit about your on-site inspection program, the implementation of the risk-based approach, and how many on-site inspections you would have conducted, let's say, the last financial year,
Okay.
and so on?
Good afternoon, Madam Chair, members. So the Compliance and Inspections Division is responsible for conducting the reviews of the registered entities, particularly the broker-dealers, investment advisors, and the self-regulatory organizations. So we currently have 53 registered broker-dealers and investment advisors. And during the last period, which we would, per 2024, we would have conducted approximately 20. So basically, if we work with the fiscal, for the commission's fiscal, we would have conducted about 15 on-site. I'm loosely calling them on-sites because during the pandemic, we would not have been doing any in-person inspections. So they have been completed as desk-based reviews. For this fiscal in 2024, we would have conducted 5 reviews as well as a thematic review of 18 entities. So we have been, and the 18 thematic reviews would have been actually AML specific. So the reviews would be, basically we would go into the entities. We are using an enhanced, within the last year in 2023, the Commission upgraded its supervisory framework, its risk-based supervisory framework, which would allow us to actually identify and prioritize the entities that we would want to conduct the reviews on. So this last fiscal would have been undertaken based on that risk-based framework.
Based on the reviews you've conducted, both on-site and desk-based, what do you consider to be the greatest source of risk for money laundering in the sector based on the level of compliance that you see from your regulated entities? What is there any particular area that you could pinpoint that you think is an exposure for money laundering?
So I think that essentially, as the chair would have rehearsed this morning in terms of part of our response, it would be in terms of the policies and procedures of the entities, and where we would look at the issues of the role of the compliance officer to enforce the policies, the compliance program, and of course all of the aspects that would surround that compliance program in terms of the ensuring customer due diligence and ensuring that the entities actually do as they would in terms of whether it is know your employees. So that those would be really the main areas that we would examine when we do our reviews. So particularly surrounding all of the ensuring that the procedures and the policies and procedures are in place.
And I don't understand this area very well myself, but I see it out there, and certain things have come to my attention. In terms of the regulation of cryptocurrency and blockchain and these types of things, there's a Netflix series called Billions, and I think somebody in Trinidad and Tobago is, based on the exchange rate, taking it to trillions. And I don't know what role you see for the SEC as a regulator, and if you've considered the type of legislation that we might need to bring, and if you are actively pursuing amendments to bring these types of digital currency transactions and investments under your purview, or whether it is something that another agency would have to deal with. I don't know if the CEO wants to answer.
Sure. And so that whole issue of crypto is wrapped up in the discussions around virtual assets. So it would be one aspect of that we are all considering. There are standards out there. We can ban it, for instance. But even if you choose to ban it, then you still have to have enforcing the capacity to do so. Long and short is, yes, we are very aware of it. It's wrapped up in the discussions pertaining to virtual assets, which we alluded to earlier.
Now, unite the thread, really, that is linking all of these entities dealing with anti-money laundering and combating financing of terrorism is really within the bosom of the last entity. That unites you all. The Office of the Attorney General and the Ministry of Legal Affairs. So we bring you to the table, last but certainly not least, because you have heard all through the discourse this morning about the need for legislation. Where are we? What do we need? Because we can have everything, all the information, but if there is no enforcement, what are we doing? Spinning top in mud. I used that analogy in the Bahamas, and they told me, you're on national television, there's no mud in the Bahamas, but we have mud here. So the primary obligation of to fulfill the obligation of the Attorney General pursuant to the Anti-Terrorism Act, implementation of targeted financial sanctions, all of these things. So we're putting the Attorney General's office front, center, and we're anxious, but you have a very heavy responsibility. So we're going to start the ending with you.
Thank you, Chair. So from the capacity of the anti-terrorism unit and tying back into the EML CFT remit, as you would have seen in our submissions, that we primarily undertake the Attorney General's obligations pursuant to the Anti-Terrorism Act, which speaks to targeted financial sanctions. We have implemented our international obligations as well as the mandates under our domestic framework largely, and we are now found compliant with that in relation to FATF Recommendation 6. We continue to implement the mandates of the United Nations Security Council resolutions, both domestically and based on their targeted financial sanctions terrorist regimes, which would be ISIL, Daesh, and Al-Qaeda, 1267, and their Taliban 1988 sanctions list. In that regard, we have what we call Task Force Charlie. We work closely with all the competent authorities in Trinidad and Tobago that are relative to countering terrorism and countering the financing of terrorism in that regard to bring persons to the table based on the intelligence, information, and investigations that are ongoing at those different entities to have persons designated as is necessary. We have designated all persons on the UN's list as well as 9 persons domestically. We have ongoing screening that takes place because it's a whole of country approach that is necessary. So we have the reporting entities screening, reporting to the supervisory authorities, the anti-terrorism units, and the other persons around the table working hand in hand with them to ensure that our EML CFT obligations in that regard are undertaken. Going further, I know that the points in relation to the legislation and implementation would have spoken to our issue of foreign terrorist fighters. Pursuant to our Anti-Terrorism Act, Section 15A, it is an offense to travel and remain in a country for the purposes of carrying out a terrorist act. You would see also, pursuant to Section 9, Subsection 7, travel and remain in a country falls under the remit of support, so given support in that regard. If you would look at the FIU's annual report, you would see significantly there has been decreases in the number of STRs that relates to terrorist financing. I think we went from a number of 167 to now 4, currently 4. And we work hand in hand with the FIU and the other supervisory authorities to ensure that the reporting obligations in relation to AML, CFT specifically in this case, is carried out and continues to be carried out, and what we are doing, because finances play the big role in relation to the terrorist act. Thankfully, we don't have any of those terrorist acts going on domestically at the moment, but we are implementing the technical compliance framework, which you would have seen is in place, as I would have alluded to earlier. It has been rated compliant by FATF. It's one of the big 6 recommendations that took us out of the grey list, and we continue to carry out our obligations in that regard. I don't know, Chair, if there are any specific questions that you would like me to speak to on this matter.
So are there any challenges, you think, to timely implementation of all of the things that you speak about?
We have had in the past a lot of challenges in relation to, because one of the major challenge that we had was the FATF recommendation 6 being to these things being taken or undertaken without delay. This basically means from the time the UN put somebody on the list, we have 24 hours to have everything done in Trinidad and Tobago. So the reporting entities then blocking and freezing, which would include in this case a judicial hearing. So we had in the past stumbling blocks, which we have gotten over by using forums such as Task Force Charlie's, by having one-on-one interactions with the judiciary, helping them to understand that these matters are matters of urgency. When we're filing our matters, it's filed under seal, and also to protect the criminal matters that may be coming out of the information that is also in those pleadings. And also we file the matters under certificates of urgencies so that the judge who is there can hear it when it comes urgently. Also, we have actively at the anti-terrorism unit, our staff continuously during the day monitoring the UN's website. We have also SOPs that we would have developed between the anti-terrorism unit and the FIU TT. We have had technical assistance in the past lent from the UN, ODC, and other foreign entities who are experts on this area. So we had these stumbling blocks, but we have overcome it, and in our view, we are now implementing it without delay.
So I can conclude that the pace of the work that is required at the Attorney General's office is proceeding as quickly as you speak.
Please, and I do apologize.
No. I understood everything you said. And we appreciate that you tried to get in everything as quickly as you could. So I have no complaint, it's just an observation. You have something?
Yes, Ms. Tijahal. I've also been accused of also speaking very quickly, so I guess we will have a good conversation. The returnees bill, particularly, that has been coming, that what we've been talking about and hearing for some time, and a lot of members of the public have been asking about it and raising concern because it treats with women and children who may have unintentionally found themselves in a situation. So a lot of community groups and so on have been advocating on their behalf. Have you all assessed the money laundering and terrorist financing risk that can arise if we have a bill that will allow persons who have been in conflict zones to return to the jurisdiction? Has it been raised with, when you have follow-up reports with CFATF and so on, from a country level, do you think that it can affect our ratings and so on, and our image, for want of a better word, as a AML CFT compliant jurisdiction and our ratings?
Thank you for that question. So firstly, in relation to the returning bill, it's currently before the LRC. As you would appreciate, there's a lot of stakeholder consultation that has gone into the bill. There are a lot of iterations that would have come out of the bill. A lot of the implementation factors will fall under the remit of Ministry of National Security, so they need those stakeholders and the relevant entities within Ministry of National Security will have to come back and feed back into the policy development and the structure of the bill. So it's a lot of back and forth in that regard. But the work is ongoing and it's before the LRC. In relation to your second question on the FTFs and the risks posed, as you would have seen in our submission, the anti-terrorism unit would have chaired the sub-working group in relation to terrorist financing, and we did take into consideration the variables, the number of FTFs that would have gone and come back as one of the factors. And as I said, even though it's not yet published and approved by Cabinet and published, there was a medium overall rating there. However, we anticipate, because of the time period within the risk assessment was carried out being 2016 to 2020, going into the beginning of 2021, and now the significant drop in SDRs, money flows, no foreign terrorist fighters going out or coming in, that risk would now be somewhat lower, and that's why we're going to continue as part of Task Force Charlie carrying out sectoral risk analysis in relation to that. All of that information is fed into the various entities that deal with the returnable and would have contributed to the returnable. But not only in that regard, we have demonstrated this information, as you would have said, to FATF and CFATF. And I think coming out of the grey list and continuously demonstrating, even though we haven't been re-rated in relation to immediate outcomes and effectiveness, because fourth round focused more so on technical compliance. Going forward, as I said, we're in a much better position now in relation to implementation to show that the framework that we have is working, and we're seeing the trends that are coming out. We are taking the risk into consideration, and that overall we have improved significantly. So even though in the past there may have been a negative light that was shed on the country in relation to the persons that would have left, we have taken a lot of steps in that regard, and it is demonstrated in the overall implementation of our framework.
Right. So the long and short is, you don't think that when the returnees bill is, or if it is approved and brought to Parliament and passed, and we allow persons to return, that there would be a significant impact on our ratings because of all the steps that you've taken, basically?
I think once we continue to take these steps, we continue to monitor the risks. That would obviously be a whole different remit once persons start returning to the country. So we'll have to take that in consideration and assess it as we go on, and put the different implementations and provisions within the framework and then have it implemented. I don't think that we should anticipate as much of a negative impact on the country once we can demonstrate that we are doing the needful.
Thanks, Chair. No, a lot of what I wanted to get covered was actually answered in that, but it had to do with the rating that we have of medium and the contributing factors for that and where it sits. So I don't know if you just want to just put the final elaboration on that. In the submission, in the TFNRA report, the data gathered resulted in the findings, and we have a current TF level of medium. And the question really around that is, what are some of the factors that would have and prevailing circumstances that would have contributed to that, and where are we going in terms of where that is?
Thank you, Member. Through you, Chair. In relation to the TF risk assessment that we would have carried out, we used the World Bank tool. The methodology in the World Bank tool has different steps to be undertaken, and there are variables therein. So one of the steps that is taken, one of the primary steps that's taken, looks at the terrorist financing threat posed by terrorist organizations. So therein we would have looked at the foreign terrorist fighters. We would have looked at whether there were any domestic threats or actions that would have been taken place in Trinidad and Tobago. We would have looked at sympathizers, recruiters, all these different categories of persons. We would have sent out questionnaires to various entities, 15 plus in Trinidad and Tobago, to get their feedback on all of the different variables that we were assessing. We would have looked at our legal framework, the processes, the procedures, together with the legislation that is in place. We would have also looked at a sectoral risk assessment, banks, FIs, the NFPPs, all these persons. And in assessing those things, based on the information that we would have gotten, based on open source information, based on research, and the factors and trends that would have come out from the FIU, information shared from the FIB, the judiciary, special branch, etc. That's how we would have analyzed using the World Bank tool to come up to the medium rating. But as I said, a lot of that has changed and continues to change given the landscape, the current landscape. So definitely when we undertake the sectoral risk assessments ongoing, it would definitely, it's anticipated that it will be a lower risk. Yes.
Well, we've heard quite an earful from quite a mouthful. And I've never seen the team, and there'll be a few in number today, some members are missing, but they're all raring to go, and they've given me eyes that they want to ask. But we have one broadcast team, and they themselves have responsibilities. The House is meeting this afternoon as well. And really, I see before me today a team of invitees from the various entities who are armed and well prepared. Yes, give me your hand, Bassanio. Fairly well. You've done very well. But we aren't finished with you yet. So you will expect to get some more questions in writing from us, and that will inform our report. And I hope that people will read reports, because a lot of reports come out of the committees, and sometimes when I read in newspapers, I realize that people are not reading. There's a lot of material. You know, people work very hard to produce these reports and to inform the community, and there is a lot of information there that sometimes people are just not aware that the question that they're asking in the press and on the radio, they have already been answered. So please, you have the Parliament channel. You can go back to YouTube, you know, ever since. You can go and read what is in Hansard. There's so many avenues for you to read and understand what has happened. So unfortunately, you know, parting is such sweet sorrow, but I must ask you to make brief closing remarks. You did extremely well with your opening remarks. I don't think we've ever had a team that was so succinct. So I know you want to keep your reputation intact for obeying instructions of the chair. So we will start with Mr. Nigel Stoddard. Mr. Patrick Solomon will follow, famous name, Mr. Kestergai. I was trying not to say that all day, you know. And Ms. Cassandra Sitahal. All of you have performed very well, so that goes on the record. I won't even give you the whole 2 minutes. You just, maybe I'm in a minute and a half.
Thank you very much, Chair and members, for inviting us. The FIU remains cognizant of its role in the fight against money laundering, terrorist financing, and proliferation financing, and the overall safeguard of the financial system of Trinidad and Tobago. Countries that demonstrate effective AML and CFT frameworks are perceived as reliable partners in international trade and investment, fostering economic growth and attracting foreign investment. The FIU will continue to prioritize the improvements of its measures, methods, manners adopted when performing its function. It is only through effective monitoring and supervision that the listed business and the non-regulated financial institutions will achieve adequate compliance with their AML, CFT, CPF requirements. While there are challenges that present themselves along the way, the FIU commits to remain steadfast and hold true to its mandate to effectively detect and deter money laundering and financing of terrorism in collaboration with local and law enforcement, regulators, and international counterparts, thereby contributing towards a safe and stable financial system. Lastly, the FIU will ensure that continued collaboration with respective stakeholders is undertaken. That is the Central Bank of Trinidad and Tobago, the Trinidad and Tobago Securities Exchange Commission, the Anti-Terrorism Unit, and NAMLAC, which includes other competent authorities. Time doesn't permit me to mention. We wish to extend our gratitude once again to the committee for this opportunity and awaits the further questions that was directed and will be directed to us and the resulting recommendations. To end again, I want to thank you, Chair, for chairing this meeting, as well as we also waiting the recommendations to look at those and implement where we can necessary to close any gaps. I thank the Chair and members for your questions.
Now for Mr. Solomon, you're not going to thank us 3 times, eh?
No, he did already.
You know?
All I would say is that I agree with what Nigel said, but I will also say that we are stronger together and that we coordinate, and we have several MOUs where we exchange information. So we try to do as much active management rather than passive management, but we need sometimes to get the support of legislation in order for us to be more effective. So you need up-to-date legislation in order to perform our functions in an effective manner. So thank you very much for inviting us, and we'll continue to work together to make sure that the system continues to be robust and resilient at the end of the day.
Thank you, Mr. Guy. Now, Kester Guy.
Yes, Chair. I will start by saying the effective monitoring of AML regime is no easy work, especially in an emerging and dynamic financial system and new and emerging risks and typologies by specialists who are bent on finding new and creative ways to manipulate the system. Nevertheless, Chair, with our continued resolve and support of each other, we remain committed to ensuring that we do our part to minimize risks associated with AML. We thank you for inviting us. We hope we've been able to share some light on our regime, not just to this August group, but the members that are the wider public that is listening. And we certainly look forward to further queries and questions that you may have so that we can continue our clarifications.
Careful what you ask for. Ms. Sitahal.
Thank you, Chair. The Anti-Terrorism Unit would like to echo the remarks of all the other entities on the table. Just to underscore that the Anti-Terrorism Unit remains committed to working closely with all our counterparts and taking a whole of government and a whole of country approach towards strengthening our framework and the implementation of our national and international AML CFT framework. We look forward to get any further questions that you all have, and thank you for having us and giving us the opportunity to be heard.
Thank you all very much. I am sure that anyone looking on, and people look on all different parts of the world, you know, and they will conclude that things are happening in a positive way. We're not there yet in Trinidad and Tobago. So you have represented your government well, I would say. Thank you for the work that you do and that you will continue to do. So all that remains for me to do is to, I don't like to say adjourn because I have a different concept, but to bring this meeting to an end. Thank you.